Last topic is asset protection. I still get a lot of questions these days from people who have had issues with, they sign personal guarantees on development loans, or they have some rental properties that are underwater and they've defaulted on them, and they're wondering, is the lender going to come after me? If they do, what assets can they take? IRAs and 401ks have a very high level of asset protection. There are different issues though. There's bankruptcy protection and then there's state law protection. They're very different. Bankruptcy protection is only available if you file for bankruptcy. There are downsides to filing for bankruptcy. There's potentially the social stigma, certainly the impact on your credit report, the fact that you don't get to take advantage of bankruptcy protection for another 10 years after filing. But there is 100% protection for your 401ks and 100% protection for your IRAs that were rollovers from 401ks or 403bs or 457s, one of those qualified plans. So those are what are called non-contributory IRAs because they came from employment, the employment context. There's also $1 million exemption if you were just writing a check to an IRA not related to your employment and we're deducting those funds. There's $1 million exemption there. Not a whole lot of people have large contributory IRAs because the limits are so small of what you can put in there. Most of them are coming out of qualified plans. But we do want to keep the two separate because of the different creditor protections.
So qualified plans are 403Bs, 401Ks, yep. 457s. And why do they have those numbers?
Well, just different institutions. 457s a lot of times are for nonprofits. 403Bs
IRS
are for
code. Don't they refer back to the IRS?
Yeah, it's all the IRS code sections that apply. So that's the protection under bankruptcy. So your 401k assets are never going away under bankruptcy. Okay? Now, non-bankruptcy, this is state law where you say, I don't want to deal with bankruptcy, I don't want to deal with the stigma, the hassle, etc. What is the protection? Your 401ks are still completely protected. 403Bs, 457s, the qualified plans here. Okay? But once you roll a 401k into an IRA, state law governs unless you're filing for bankruptcy, which is a federal relief or a federal cause of action. So the biggest issue, or the people who oftentimes look at this, I have a client who's does high-risk pregnancies and births. And there's a statute of limitations that is, I believe it's 21 years from the day that the day he gives the last child, the day he helps give birth to the last child, or helps deliver the last child, because if he damages or injures that child at birth, the child has until age 18 to file a lawsuit, or 3 years after age 18 to file a lawsuit. So that doctor is sitting there saying, I want to make sure my assets are protected. I don't know if I want to roll out of a 401k into an IRA, because I know my 401k is totally protected. I know my IRA, if I don't want to go the bankruptcy route under state law, is only protected to the extent I need it. Now, who wants to have some judge telling you how much money you need and how much money you don't need? So people who are particularly concerned about those types of risks may actually leave their money in a 401k longer term. A lot of times people will also will actually accelerate distributions from their IRA, and they'll buy life insurance because the life insurance can pass free of estate tax. This is for people typically who have taxable estates, okay? Because the problem with an IRA is if you leave the money in the IRA, it continues growing and growing and growing. Well, we hope it continues growing and growing and growing. Well, that's also growing the size of your estate. Well, that means it's subject to estate taxes. But if we could instead take that money out early, get it into a special type of a trust where it's outside of your estate and that future growth is outside of your estate, there could be some very significant estate tax and income tax savings. So it's not always a no-brainer to defer as long as possible. Inherited IRAs, there is no asset protection at all for inherited IRAs. That's one of the reasons that we leave them in special trusts. charitable gift annuities, charitable remainder trusts. The best asset protection is in a standalone retirement trust that has that accumulation feature that we talked about. There are several recent cases, one just from a few weeks ago, where an inherited or a beneficiary lost an inherited IRA to a lawsuit. So they are not immune from creditors. So in your hands as mom and dad, they're almost totally immune if they're structured properly. In the kids' hands, all of that immunity goes away unless you set up a special structure to protect it.
When would you start beginning to look, or somebody should start inquiring about an IRA trust? How much, because we're going to have fees related to this, so at a certain level it doesn't make sense to do all this planning,
yeah.
But at another level it makes perfect sense.
That's a good question. People generally start looking at IRA trusts. The bare minimum is usually about $500,000 in an IRA. Oftentimes more likely or a better fit is if it's $1 million plus. There are some factors that cause people to look more versus less. If they have special needs children, then they are almost certainly going to set up a standalone IRA trust. If they have a lot of charitable intent, they'll probably set up something like a gift annuity or a charitable remainder trust. If they know that the kids are extremely financially irresponsible, then they're more inclined to look at those types of trusts. And then pretty much anybody with an IRA exceeding $2 million is doing a standalone IRA trust, unless they're doing a lot of charitable planning. But if it's going to the kids, they're almost universally doing these trusts because they don't want that $2 million being lost to whatever ills are out there. The question is, designating a charity as a beneficiary of an IRA. They are not a designated beneficiary. They don't qualify for that. But in that one case, there's an exception that allows you to avoid the problem. And the exception is, as long as the charitable gift is distributed by September 15th of the year following the year of death, then it does not disqualify everything else. So unfortunately, it's a hybrid type of deal. It does taint everything, but there's an easy way to prevent it from tainting the designated beneficiary status.
What 99% of individuals do is they leave their IRD assets to the children, and then if they've named a charitable organization, they do it in their living trust or their will. And it should be the exact opposite, because the charity doesn't pay any income taxes on the assets it receives from the IRD assets, and your kids are not going to be subject to income taxes for the assets they receive under your will and trust. I would venture to guess that in the next 2 years, or maybe even the next 5 years, income taxes are going to be more of an issue for most of us than maybe the estate and gift tax issues.
Oh, sure. So yeah, the estate tax is targeting the top 2 or 3% of the country.
Yes. And whereas income taxes are going to be just a major hit. And most of our families and the beneficiaries have no clue. I can't even remember who I named as my designated beneficiary on my IRA that I put together prior to my marriage.
It was me.
It was you. So get a copy and at least see who's the designated IRA. And remember, on commercial annuities, there is no stretch. Okay? I'm not talking about a commercial annuity inside of an IRA. I'm talking about a commercial annuity outside of an IRA.
So the IRA trust, the standalone retirement trust, does allow a stretch. It has special provisions that a living trust doesn't. Well, actually it has special limitations that are not present, should not be present in a living trust, that allows it to qualify for the stretch out treatment exactly the same way an individual would.
For primary and secondary?
Yeah, well, no, primary, the spouse should always, in almost every case, I think in every case, the spouse should be named as primary beneficiary. The surviving spouse can roll it into her own IRA. It's a spousal rollover. She gets actual lifetime tax deferral, not just life expectancy. The contingent should be, if the standalone IRA trust is proper, the contingent beneficiary should be that trust.
See, what happens when we put our will, durable power of attorney, the advanced health care directive together, usually the attorney says, here's a letter, go to your financial institutions and get your assets named in the living trust. And by letter. In other words, normally in your office, correct, you don't actually transfer the assets from the brokerage account or the financial institutions into the name of the trust. You pretty much assist the client to do so?
Well, it depends on it, but if we just assist, we always review afterward.
Yes.
And we prepare a schedule that's attached to the trust that says, okay, this account is now officially in the trust. We've seen the documentation. It's been done. When I do standalone IRA trusts, because the beneficiary designations are so woefully inadequate as prepared by most of these custodians, I write my own. And then I do that whole.
You want to repeat that again?
Yeah, when I do standalone IRA trusts and we're doing the stretch out planning, I draft my own designated beneficiary form. I don't use what the custodians use because they're really poorly done. There's all kinds of contradictory language. There are bad default rules in there. They don't account for remote contingencies. What if your spouse and your children are gone? A lot of them don't let you plan beyond that contingency. And so I custom draft them, and as you might guess, they're all huge fans of mine. I fight with them all the time. Well, you can't do this. You can't change our form. Why? Show me the law where I can't change your form.
So and most of the financial institutions don't understand this kind of complexity. So if you have a large IRA, if you have a large 401k, take this session today as just maybe, the tip. Hey, we ought to explore a little further and some more, because it is complicated.
Yeah, the question is, if you name your spouse as beneficiary of an IRA, she rolls it her own inherited IRA, can she name a beneficiary? Absolutely. She can name the pool boy, and you can't stop her, okay? So it's just, that's the way it goes. And that's why some, usually husbands, because it's just the way they're wired, I guess, they want to leave it in trust for the surviving spouse because they say, well, wait a minute, what if she remarries some jerk and blah, blah, blah. You can do that, but you're going to sacrifice some income tax deferral, and I really don't think generally it's the right thing to do.
The national statistic is that all IRD assets are spent within 18 months of your death, no matter what the size of those assets are. That's a national average. We know that every one of us are an exception to that rule. So next week, well, first of all, Matt, great job. Thank you.